We are delighted to have Joshua Jowitt with us today, who is a visitor at the Cambridge Centre for Animal Rights Law. Josh is a lecturer in law at Newcastle University, where he currently teaches public law, legal theory, and counter-terrorism, and he'll soon also be offering an animal rights law course there. Josh holds an MA in law from the University of Cambridge, an LLM from the University of Warwick, and a PhD from Durham Law School. Josh's research interests focus around contemporary natural law justifications for legal normativity, and he looks at the extent to which such theories impose limits on legislative discretion to recognize and enforce legal rights for non-human animals. During his stay at our center as a visitor, Josh is working on a natural law account of the normative foundations of legal personhood and the implications of this approach for both the legal status of non-human animals and their possession of legal rights. In his presentation today, entitled "The Elephant in the Room, Happy and the Normative Structure of Legal Personhood," Josh will be telling us more about his research. Josh, I'm going to hand over to you. Thanks a lot for being with us today, and the floor is yours.
No, thank you, Raphael. I'm going to attempt to do the screen share. Oh, God, I've closed my PowerPoint. This is a great start we've got off to, isn't it? Here we go. Thank you for having me anyway, even if I've got off to potentially the worst start imaginable. It's kind of a tough crowd to follow. I think there's been some incredible presentations that have been given so far as part of the Talking Animals series. So I'm really pleased to be able to share my research with you. And also thank you to you and the Centre for Animal Rights Law for having me as a visitor, even though we're not all able to be together in Cambridge. I know I'm still benefiting massively from the chance to talk about these issues with other like-minded people. So thank you to you and the Centre for hosting me and giving me this chance. Before I dive in, I just want to check whether this screen share is working. Can you give me a nod, Raphael? Yeah, brilliant.
I can see it, yeah.
Cracking. So, as I said, I'm finding this very, very useful. So before I do dive into my presentation today, I want to get two preliminary issues out of the way. Firstly, because given the title of the talk, you might not be expecting this content. I do feel as I should give you a warning for some potentially distressing content that's coming up towards the end of this talk. I am going to be talking about case law from the UK touching the crime of rape and also the issue of slavery. If those are particularly worrying to you, then the slides are going to be slide number 19 and number 20. It's towards the end of the talk. But I will give you a heads up when those are coming up so that you can choose to avoid that content if you wish. The second thing I'd like to give you, I suppose, a bit of an insight into is my own background. And this is something that Raphael did mention, but I feel I owe it to you to explain somewhat where I'm coming from when I'm tackling the issue that I'm going to be talking about today. So, as Raphael kindly said, I did my PhD in the field of legal normativity at the University of Durham. So what I'm interested in is where that ought comes from in law. Why does law make a claim to us as to be something that's valid and something that we have a reason to comply with? And I started out in the lingo as what's known as, I suppose, an inclusive legal positivist, or maybe a soft natural lawyer. So I saw the obligation of law as distinct from that of morality, right? They're two separate things. Yeah, the law perhaps can integrate morality if it chooses to. So the 14th Amendment in the US Constitution in particular is a good example of the law explicitly recognizing the idea of equality. But my opinion was that's pretty much it. There's nothing deeper than that, no necessary connection between law and morality. But over the course of my PhD, I got converted to what, by my own admission, is actually a fairly fringe position, which is that of a very strong natural lawyer, which is the idea that unless there's any kind of moral justification for a law, then it's not really law at all. It's not something we should follow. Now, the reason I'm telling you this is because animal law and animal rights law in particular wasn't really on my horizon whatsoever until the beginning of 2016 when a friend sent me this photograph, and he was like, here, this is a really funny news story. Now, those of you who are familiar with the field might recognize who this is, but for the benefit of those of you who don't, this is a picture of a macaque called Naruto. And Naruto was the center of a famous piece of litigation in the US, commonly known as the monkey selfie case. And the question before the courts was, given Naruto took this photograph of himself, this is a selfie, and it's a smile I think we can all aspire to. It's certainly better than I can come up with these teeth that I've got. Who owns the copyright of this image? Should it be the person who owned the camera and had left it in the rainforest? Or should it have been Naruto, because he was the author of the image? And nowhere in US copyright law at the time did it specifically say that the owner of the copyright had to be human. Now, this case absolutely fascinated me. And I remember talking to my mum about this over Christmas dinner, maybe 10 months after. That's the kind of Christmas we have in our house. It's party central, let me tell you. So I was talking about my work. And I said how interesting I found it. And I thought this was a real dilemma. And my mum just said, don't be daft, Josh, it's a bloody monkey. And I said, well, actually, Mum, it's an ape. And then she didn't talk to me for 2 days. But I actually found it really interesting that we'd had such gut reactions on the opposite end of the spectrum about whether we thought this was a frivolous piece of litigation or something that actually touched on a really substantive issue. And from then on, that's where I got interested in the idea of natural law and legislative discretion. Now, if anybody in this lecture has read anything that I've published on this idea already, then you'll know what I mean when I say I've potentially got a fringe view here. So this talk is actually not going to be my normal kind of show. I'm going to try and give you a more modest claim, focused specifically on the litigation concerning Happy the elephant in the US at the moment. And the modest claim I'm going to try and talk you around with today is this, quite simply, that the bench in the Happy litigation have been wrong in deferring the issue to the legislature. Now, the reason I'm giving you this softer claim is because I'm fully aware my normal show is something that a lot of people don't like, particularly practitioners. I mean, if you go into a courtroom and say, well, actually, there's a very strong moral reason why you shouldn't apply this particular law because it's not law at all, the judge is going to laugh you out. And I'll be the first person to admit that. So I'm giving you something here that I hope will be more persuasive to those of you who are more positivistically inclined, those of you who are more comfortable working with legal doctrine. Hopefully we can all get on board with this. And I think Gustav Radbruch can give the judges in the Happy litigation a very good reason why they should depart from the position of deference to the legislature that they seem to have adopted. And I'm going to close the paper by arguing that the common law is actually very, very well suited to this. And I'm going to give you the examples of cases I've mentioned where I feel judges have adopted Radbruch's position in changing the law against potentially their better interest to defer to the legislature. They didn't expressly say they were adopting Radbruch's position, but I think if you examine the reasoning in each of the two judgments I'm going to show you, that's pretty much what they were actually doing. Okay, so that's the structure of the talk. That's the 3 steps I'm going to take you down. And I'm going to begin then by introducing you to Happy. This is not a selfie, you'll be shocked to hear, but that is a picture of Happy nonetheless. And Happy is a female Asian elephant. Nobody knows how old she actually is, but the best efforts of the Non-Human Rights Project seem to have led us to the conclusion she was probably taken from her state of liberty in the Thai rainforest with 6 other elephant calves at some point in the 1970s. So that gives us a ballpark figure. She's probably in her late 40s, early 50s. She was taken to the United States, initially to California, where she was made to perform for paying guests in amusement parks and varying traveling exhibitions, and eventually ended up in the Bronx Zoo in New York. Now, she did originally have a companion when she moved to New York, but the companion died in 2006. So Happy's now been on her own for the better part of 15 years. And this isolation, together with fairly small and fairly cramped living conditions have led elephant behavioral experts to believe that her living accommodation is a significant factor, and a significant exacerbating factor in particular, to a whole variety of both physical and mental ailments. So she's had a tough life, and it's not got any better for her in what might be considered her retirement. Now, this has raised a legal issue that the Non-Human Rights Project first got involved in 2018. And again, I'm going to assume that most people know what the Non-Human Rights Project is, but for the benefit of those who don't, this is a civil rights organization based in the US whose sole purpose is to try and extend civil rights to non-human animals. The clue's in the name, Non-Human Rights Project. Now, they first announced their decision to get behind Happy's case and to file a writ for habeas corpus in 2018. And since then, in some shape or form, this case has been rumbling through the state court system in New York. So this is not happening at the federal level, this is happening at the state level. Now, the problem faced by the Non-Human Rights Project, however, it is a fairly simple one. Whether it's at the federal level or at the state level, courts in the United States, whenever they've been faced with the issue of legal personhood for animals or otherwise legally enforceable rights for non-human animals, is not something that they're able to do off their own back. They've always been very deferential since the cetaceans case to say, this is one for the legislature. We've got no problem with this in principle, but the legislature are the ones that really need to tell us this is a step that we are able to go in. I'm aware, I should say at this point, that there is some debate about whether legal personhood is even needed for the enjoyment of animal rights. And those of you who attended the last lecture in this talk will have heard Eva Burnett-Kempers, my fellow visitor, giving a very, very good overview of why perhaps that's not necessarily true, particularly in civil law jurisdictions. Others of you might have come across Visa Kurki's monograph, where again he questions the connection between legal personhood and being a legal rights holder. But that's not something I'm prepared to go into in this talk. I'm going to simply take the US system at its word here and say that if the US system thinks that something needs to be a legal person to be a rights holder, okay, that's the playing field that they've laid out for me to play in. So I'm not questioning in very much detail the idea of legal personhood here. I'm just agreeing with what I'm being told is the case in that jurisdiction. Now, you'll be shocked to hear then that that position is one that the courts are adopting in Happy's case. And they're relying on other cases that were heard in New York in recent years, particularly Lavery number 1 and Lavery number 2, cases again brought by the Non-Human Rights Project to claim habeas corpus for a chimpanzee named Tommy. And in Lavery number 1 and number 2, the courts said, look, this is one for the legislature. Those decisions were explicitly adopted by the New York Supreme Court, which is what they call their Court of Appeals. Confusingly, the Supreme Court isn't the highest court in New York, but they adopted Lavery 1 and 2 as binding precedent to them when they refused the permission for the writ for Happy on the 17th of December 2020. So that's the current state of affairs where we are. This writ has been denied because the court in New York believes it's bound by precedent to see this as something that the legislature should do instead of them. Now, the Non-Human Rights Project have appealed. That appeal has been submitted to the state final court in Albany. And in order for this appeal to be heard, 2 of the 7 judges on the appellate bench in Albany need to accept the petition. So the question before us, I suppose, now is this going to happen? Are 2 of the 7 judges actually going to turn around and say, yes, we think this is a case that we are able to contribute to, when precedent is definitely stacked against them? Now, an interesting thing that we need to focus on here, I think, is that actually some of the judges in the New York circuit seem to accept the fact, justifying why Happy might be deserving of the status as legal person and of the writ of habeas corpus. There's a very famous concurrence in Lavery number 2 in particular by Justice Faehey, which I'm going to come to later in the talk. But that was endorsed by the justice in the initial trial, the initial hearing, sorry, in the Happy case, Justice Stewart. And I've given you a quotation here, which I find quite striking, which shows you actually the judges seem to be on board with the point that Happy might deserve legal personhood. Justice Stewart says, Happy is an extraordinary animal with complex cognitive abilities, an intelligent being with advanced analytic abilities akin to human beings. She is an intelligent, autonomous being who should be treated with respect and dignity, and who may be entitled to liberty. So the facts here aren't necessarily being questioned. The idea that Happy potentially deserves this recognition on the face of it is something that the judges might be sympathetic to. As I've kind of been hammering home, I think the legal issue that we really need to confront is a slightly different one. Even though the judges might accept the legal reasoning in the non-human rights case, they're just refusing to apply it because they don't think they're allowed to. They don't think it's something they should do. And I've looked at the decision that was handed down by the court in the Happy case on the 17th of December, and the entire judgment is only 15 lines long. There's only 15 lines in it. Now compare that to the evidence and the case that was submitted by the Non-Human Rights Project, which comes to well over 450 pages worth of affidavits and written submissions in favour. The courts don't even look at it. And the reason why they're not even taking that into account is because of what I've got on the screen here. This is the closing part of the judgment. Clearly saying here a judicial determination that species other than Homo sapiens are persons for some juridical purposes and therefore have certain rights would lead to a labyrinth of questions that common law processes are ill-equipped to answer. As we said in Lavery, the decisions of whether and how to integrate other species into legal constructs designed for humans is a matter better suited to the legislative process. So judges might accept the arguments, but they don't think it's a question that they are able to give an answer to because they think it's something the legislature should look at instead. So what we're asking for really is a fundamental shift in that. That is a judicial attitude that I think really needs to change here. And I'd like to humour me with an example that a colleague used to use when introducing the idea of judicial discretion to first-year students here at Newcastle. I think it's a great example, so I'm ripping it off absolutely shamelessly, but I'm going to introduce you to what my colleague thinks is the best legal drama that's ever been made in the history of cinema. And it's this wonderful film, Miracle on 34th Street. Now, you might be thinking, what the hell is this guy on about now? So humour me. For those of you who've not seen the film, it's about a chap called Kris Kringle. He's the man on the left, you'll be shocked to hear, who believes he's Santa. Now, he's put on in front of a court to determine whether or not he's insane. And the rule that the court are having to apply here is that anybody who believes himself to be someone that they are not is insane. So on the face of it, you've got a man claiming to be somebody who's fictional. So definitionally, he seems to be insane. The court call all kind of witnesses here to try and get a case to have this dealt with in a very, very legally acceptable way. They call an Air Force general for evidence who says, look, I've flown over the North Pole hundreds of times and I've never seen any workshops, so you're not real, sunshine. And Kris Kringle just says, well, of course you've not seen them because they're magic. They're invisible. You can't see them. He gets asked directly to prove his claim by making some reindeer fly and prove if you're Santa, you can make these reindeer fly. And he says, well, don't be ridiculous. I can only make reindeer fly on Christmas and it's not Christmas Day, so I can't do this. Now, and eventually the lawyer is summoned to the judge's chambers and the judge says, look, I really want to allow this man off, but I don't think I'm allowed to. I don't think I have the discretion to make this particular call. Because on the face of it, the legal rules I've got are directing me towards finding him insane. Now, eventually what the judge does is get a flash of inspiration in the form of a dollar bill that he sees passed in front of him. And on the dollar bill, it says those words, "In God we trust." And the judge here kind of has an epiphany moment. And he says, well, there's no proof here in the idea of God, but we trust in him nonetheless. So I should trust in my own judgment in this case and do what I think is right. Because I've got that discretion and I should have confidence in my own abilities as a judge to reach the right conclusion here. To hell with what's gone before me. So I guess what I'm asking for in Happy's case is for that epiphany to happen again, and we might end up with the miracle on Eagle Street, which is the street in Albany where the New York Final Court of Appeals actually is. Maybe that could be the new title of this talk, I don't know. But we need to give the courts then, I suppose, a reason to do what the judge in the Miracle on 34th Street did. We need to give them a reason to say, look, let's go with what we know to be right here, rather than see ourselves be bound by an unjust precedent. Okay, so quite simply, judges need to acknowledge the elephant in the room. By deferring to the legislature in the way that they're doing, they're not engaging with facts that they appear to be acknowledging as valid. The Non-Human Rights Project in particular has said, look, the evidence that we put forward from elephant behavioral experts in particular is not being challenged. Like this is not something that is being disputed whatsoever. So the NHRP have done a great job, I think, in convincing the court that there is a valid case here. But what we need to do is convince the judges that it's one they're able to resolve. So we're going to now move into the second part of the talk, which is the solution. And I'm going to give you a solution based in the writing of Gustav Radbruch. Now, the piece in particular I want to talk about is referenced at the bottom left of the screen here. It was originally published in 1946 in a German journal. And it was only translated into English and published in English in 2006 in the Oxford Journal of Legal Studies. So that's why there's a confusion with the dates there. But Gustav Radbruch was a German jurist and a legal scholar. And he begins this article by giving an account of grudge informer trials in post-war Germany. And the grudge informers were people who abused Nazi legislation to report people of crimes that they just wanted to be rid of, whether it was a political rival, whether it was an unfaithful spouse. They would report them as being critics of the regime, knowing that the regime would then go and execute them. Now, the post-war German courts then had to realize, well, what do we do with all of these people who abuse the German rules in this particular way? Do we find them guilty of a crime? Even though what they did at the time was completely fine according to principles of positive law. Now, Radbruch said, well, judges really need to take some responsibility for this. Judges in the Nazi era should have seen that these rules were bad and they should have used their discretion to try and avoid them. And the reason he says that the judges should have done this is because of his pretty unique way of seeing a legal system as being comprised of three fundamental values. The three values that Radbruch said need to be represented in any system are, firstly, utility. Legal rules and the legal system need to be driving towards some kind of public benefit. Legal certainty, they need to be stable. And thirdly, the pursuit of justice. And you can see where I'm going this with now, Kenny, by bringing the idea of justice. And he said, look, the idea of justice is a contentious one, because ultimately that's a moral standard. But if you think about it carefully, justice needs to be in any kind of legal order. And the quote at the bottom gives you a sense as to why he thought that. He said, where there's not even an attempt at justice within a legal rule or a legal system, where equality in particular, the core of justice, is deliberately betrayed in the issuance of positive law, then the statute or the rule in question is not merely flawed law, it lacks completely the very nature of law. Now, that's quite dense, so I'm just going to unpack that for you briefly to give you a better idea of what he means. He means if you get a rule that is so unjust, it's so substantively unjust that it's just morally reprehensible, then actually by enforcing that law, you're undermining the other two components of a legal system. You are undermining the idea of utility, and you're undermining the idea of legal certainty by introducing such a morally reprehensible rule into the system. So therefore, if you have a massive injustice, it cannot be seen as a valid law because it ultimately will bring the entire system crashing down. And he then said that judges should work to avoid respecting these unjust rules and work to avoid them, particularly at the appellate level where they have the discretion to be able to do so. So I suppose we're not saying here lex in justa non est lex, we're saying lex maxima in justa non est lex. A very unjust law cannot be considered to be law at all because it undermines the very, very functioning of the legal system. Now, this idea got a little bit of traction and a little bit more exposure in the English-speaking world by its significant featuring in the Hart and Fuller debate, published in the Harvard Law Review in 1957. I should say, those of you who recognize this as a picture of Lon Fuller, I've not chosen this picture just because I am a natural lawyer, so I want to trash Hart and expose Fuller. This is purely practical. I couldn't find a nice high-res picture of Hart on my internet troll, so you're stuck with looking at Fuller, I'm afraid. Now, Hart and Fuller discussed Radbrook's article in quite a bit of detail in this back and forth in the Harvard Law Review. Hart was quite dismissive. He said this is a passionate appeal that's not really supported by any detailed reasoning, and kind of thought it overvalued the designation of law that Radbrook was putting on it. He said it doesn't matter whether a judge thinks it's law or not if they're still going to feel an obligation to follow it because they're terrified they'll be executed if they don't follow it. You know, you're kind of playing too much here. And Fuller said this is overlooking the point Radbrook's trying to make, that actually a severe injustice in a particular legal rule isn't necessarily law per se. It can't be law because it undermines the functioning of the entire system. And Fuller accuses Hart of overlooking that particular problem. But the interesting thing worth taking from the Hart and Fuller thing, from my purposes in this talk today, is all of them agreed that this kind of judicial intervention, the idea that a judge should feel free to intervene in the event of an unjust law, really should be a last resort. They all said that actually the best way for the German grudge informers in particular to deal with this would be to issue a retroactive statute and say that all people who abuse the grudge informer legislation are guilty retroactively. But in the absence of that, in the absence of a statute, then judicial intervention could be warranted. So even the people proposing this idea are saying it's less than ideal, but in the absence of any legislative action, the judges don't have a choice but to act. So let's bring it back to Happy. The judges in New York and in the US federal system have said repeatedly that they are unwilling to act unless there is legislative guidance. The legislature have not acted. This is not coming. It doesn't look like it's going to be coming anytime soon. So if the bench agree that there is an equality issue here, remember Radbrook thought that the paradigm case of an injustice that might trigger his idea of judicial activism was that of an unequal application of law, that you are not applying and treating like case alike. He thought that was a paradigm example here. So if we're at the point where the bench, that we have a situation here where like cases aren't being treated alike, and that the legislation isn't coming, we've got a reason straight away. We've got a reason here for the judges to actually act. Now, this is the point of any difficult legal theory paper touching on natural law, where I'd probably have to go off on some severe deontological justification for why there might be a case here. But luckily for you, and perhaps even more luckily for me, I don't need to do that today because the judges have done it for me. I'm going to bring you back here to the claim that Justice Stewart made in the original decision made by the court in Happy's case. And I've put the bit in bold that I think is relevant to Radbrook's point. She's an intelligent being with advanced analytic abilities akin to human beings. She's an intelligent, autonomous being who should be treated with respect and dignity and who may be entitled to liberty. So the judges have done the hard work for me here, and they've already accepted that there is the issue of inequality present here in Happy's case. What more do we want for them to acknowledge here than that this is a being that is capable of benefiting from a habeas corpus writ? Now, if you think that's powerful, let's take a look at the Faehey concurrence, which I touched on early. This on the left, this is Justice Eugene Faehey. He's one of the 7 judges that the Non-Human Rights Project need to convince to hear the appeal in the highest appellate court in New York. And he's on record in the previous decision of Lavery concerning Tommy the chimp and that writ for habeas corpus there, as saying something quite remarkable. And I've given you a selected quotation here of his concurring judgment in that decision. He said, in the interval since we first denied leave to the Non-Human Rights Project in cases concerning animal rights, I have struggled with whether or not this was the right decision. The issue whether a non-human animal has a fundamental right to liberty protected by a writ of habeas corpus is profound and far-reaching. It speaks to our relationship with all life around us, and ultimately, we will not be able to ignore it. Whilst it may be arguable that a chimpanzee is not a person, there is no doubt that it is not merely a thing. So again, Faehey here, I think, is arguing, look, what I want to do here is argue in favor of animal rights. I would do this if I were able to do so. Right? If this is something that I thought was suited to the courts, and if I can have a reason to think that this is a problem I can deal with, here's my views as a private citizen that I actually would like to bring to the table. However, he dismissed Lavery for the same reason as all the other judges. I think this is one I should defer to the legislature about. Well, Radbrook's given him his reason. Radbrook, I think, has given Justice Faehey the reason he needs to not only hear Happy's case, but to also depart from the precedent that he feels bound by and say, look, I'm going to rule where my gut is here. I'm going to rule with what I believe the right outcome is, rather than the injustice that I feel bound to uphold because of binding precedent. Now, at this point, I feel as though I should at least turn to the skeptics of this case so far and do a little bit of philosophy. So you'll remember Hart criticised Radbrook's theory as being a bit thin, right? There's no real reason here for a judge to see this as acting upon them. There's no kind of real normative engagement with the issue at hand. So what if the judges agree? What if the judges on the bench actually agree with me, with Hart here, and say there's not enough for me to see this as a reason for me to act on? I'm going to bring in Christine Korsgaard for a second. And Christine Korsgaard wrote a wonderful article that, again, I've referenced in the bottom left of this slide, where she tried to justify the legal enforcement of animal rights from a Kantian perspective. Now, I'm not going to argue for or against the Kantian perspective, because I think the main heavy work that she does in saying why that's something the law should account for is directly translatable to Radbrook's starting point, which is, let's see this as a fundamental injustice that undermines the legal system. And the instrumental necessity point is the one that Korsgaard brings in. She says, look, if status X is necessary to resolve problem Y, then X is quite simply something that the law has a duty to respond to. So in Happy's situation, if this inequality that the judges accept is present, I'm going to keep saying that, the judges accept here that there is an equality issue. If they accept that that issue can only be rectified by the writ of habeas corpus, and legal personhood is necessary for a writ of habeas corpus to succeed, then instrumental necessity requires the courts to acknowledge that that legal personhood exists in Happy if the legislature fails to do so. Now, those of you who might be of a formalist persuasion will recognize that as purely deductive logic. And that's why I think it's a persuasive one for the court to actually look to here as backing up Radbrook's reason, right? If these judges are formalistically minded, then instrumental reasoning is pure deductive reasoning. So it's something that they should see as persuasive if they adopt the starting point that Justice Stewart did in the court of first instance and that Justice Faehey did in the Lavery decision. So I think that provides a good reason to see this as something that the New York Court of Appeals should take quite seriously. Now, just to recap before I move into some other examples from other areas of case law, the key issue then is one of habeas corpus here. Should the courts grant the writ of habeas corpus to Happy? Now, the whole point of habeas corpus is to protect the individual's freedom. So it makes sense that they should only be granted to beings that are capable of enjoying and possessing freedom. Again, the courts accepted that Happy can do that. the Non-Human Rights Project have made that point very well, and it's something I think the courts have actually accepted. So I think then that the judges do have a good reason to act here by adopting Radbrook's point, building in Coast Guard's instrumental necessity justification. The courts here have a very strong reason to have reached the point where we have our miracle on Eagle Street. You might say this is a bit revolutionary, though, that we are recognizing here by common law an entire new class of legal being, and something like that should really be dealt with by statute. I'm going to give you two examples where I think actually the common law has done this in the past. And it's not only something that the common law is well suited to, but actually the whole point of the common law is to advance the law in areas where the legislature are failing to act. And this is where I'm going to remind you of my content warning. The next slide, I'm going to be dealing with a case involving rape, and the one afterwards will be dealing with slavery. So if that's something you don't want to put yourself through, you might want to look away for the next few minutes or so. Give you time to do that. Okay, so the first case I'm going to bring you to, I should say as well, I'm sorry, the two examples I'm going to use are both from the UK. The reason I've picked them is just because I think they're illustrative of the point that I want to make, and this is a jurisdiction that I work in. It's what I'm most familiar to. I am sure similar examples can be found in every single common law jurisdiction. It's just these are the ones I've picked on because it's what I know. And the first one is R&R. Now, the facts of R&R are horrible. I'm not going to beat about the bush there. There's a husband and a wife who were separated pending divorce. The husband broke into the wife's accommodation and subjected her to a violent and brutal rape. He was convicted at trial but appealed. And the appeal was predicated on what at the time, look at the date here, you might be shocked, this is 1991, but what at the time in England and Wales was a valid common law defence. And that defence was that marriage implied automatic consent to sexual intercourse at any point that a wife could not refuse. So a husband could not legally rape his wife because of this marital rape exemption. Now, this reached all the way to the highest court in the UK at the time, the House of Lords, and the court took one look at it and said, no, we are not going to apply the marital rape exemption here whatsoever. And the reason why was actually first advanced by the Court of Appeal, but the House of Lords 100% endorse the Court of Appeal's reasoning, and it is this. We don't mind convicting him retroactively because this is not the creation of a new offence. It is the removal of a common law fiction which has become anachronistic and offensive. And we consider that it is our duty, having reached that conclusion, to act upon it. And those words were written by and endorsed by Lord Keith, who's the chap on the left here. I don't know how much clearer that can reflect Radbrook's reasoning for judicial action. It's almost textbook application of what I've given to you so far. The judges here have seen a tantamount injustice in the law where you're not treating like cases alike because of an arbitrary status of marriage. And they are waiting for legislation to rectify this, but it's taking a long time and it's not coming in England and Wales. So you know what? They're acting. They're acting to remove this common law fiction that is anachronistic and offensive. That's what Radbrook's saying the judges should do, and that is what the judges did here in this case. The second case I want to show you again from the UK, famous case called Somerset and Stewart. And the facts here, James Somerset was an enslaved human being, and he was purchased by Charles Stewart in Boston in Massachusetts. Now, Stewart, the slave owner, returned to England and brought James Somerset with him, but James escaped. And when he was recaptured, the question was whether or not he was considered a slave under English law, even because there was no statute there saying that slavery was allowed under English law. This was a common law presumption. And Lord Mansfield, the Lord Chancellor at the time, the guy on the left, said no. Right, if this is in the domain of common law, then as a judge, I have discretion here to decide what I want to. And the state of slavery is of such a nature that is incapable of being introduced on any reason, but only by positive law. Here's the Radbrookian content. Are you ready? It is so odious that nothing can be suffered to support it but positive law. So whatever inconveniences may follow from the decision, I cannot say this case is allowed or approved by the law of England. And so Mr. Stewart must be discharged. Again, textbook application of Radbrook here. What he's saying is that this is an absolutely abhorrent institution. It emerges from tantamount injustice, and therefore the law can't recognise it. And the reason I've picked this as particularly relevant to Happy is because Lord Mansfield touches directly on the issue of legal uncertainty here. Remember, the court in Happy is saying this is something that would cause great confusion. It needs to be thought through by the legislature if animals are going to be granted rights in the way that the Non-Human Rights Project want. Lord Mansfield here is saying that's rubbish. Whatever the inconveniences are that follow from the decision, the injustice means that I cannot say this case is allowed. So the courts have done this in the past, and I think they should do it with Happy here as well. Now, I am close to wrapping up, but I want to address one final objection that you might raise here, which is that this is substantively different to what the courts have done so far in Happy's case, or what I'm asking them to do in Happy's case either, because what R&R and Somerset and Stewart are doing is setting aside an unjust legal rule, whereas what Happy's case is actually advocating for is the creation of a new legal class. Now, I don't think that's the right way of seeing it. I think those are both opposite sides of exactly the same coin. Because ultimately, what we're doing here is reclassifying a woman as a full legal person who is not allowed to be raped under law. You're bringing the woman into the full category of legal personhood. And the same with James Somerset. The law saw him as a chattel. The law saw him as a piece of property. And a result of the case was that he had his legal personhood recognised by the law of England and Wales. So I think actually what the courts are doing in these cases is exactly the same as what I'm asking the court to do in Happy's case. So that's me done. My conclusion is quite simple. The reason that Non-Human Rights Project are using the common law writ of habeas corpus in the state courts is because the state courts have discretion to take these arguments into account if they want to. Kevin Schneider, the executive director of the project, gave a talk to the UKA Law Society back in January, and I asked him why is that the case. He said, well, it's exactly because the courts have discretion that they don't have in the federal courts. So that's why we're using the state courts. So the flexibility that the courts have is something that everybody recognises, and I think they should use it. Judges have acknowledged the merits of the case. They just need a reason to be told it's one they should adopt, and I think Radbrook gives us that reason. So thank you for listening, everybody. I think I've come in just on time, 45 minutes. Look at that, Raphael. So I'm happy to take any questions you might have. Thank you for listening.